The AR-15, the lower receiver or the upper receiver, does not qualify as a firearm according to the Gun Control Act. The ATF knows it, and they don't want you to know it. That and a little bit more here on this episode of Guns and Gadgets. Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. It is Monday, the Monday morning grind, brought to us by Blackout Coffee. They are having a special. You can get 25% off of their holiday flavors that are still in stock. You can do that by using the link down below, blackoutcoffee.com/GNG, and use coupon code HOLIDAY25. It is an affiliate link, a little bit helps this channel, but you get some great coffee, and 25% off is a steal. All right, so with everything going on right now around the ATF, whether it's the Polymer 80 issue, the Q Honey Badger issue, the SB Tactical issue, or even the new letter regarding the classifications of pistol braces, the ATF, as we know, kind of does things on their own and flip-flops a lot. Well, I'm going to talk to you about something that I mentioned actually back in February that really needs to get out again now. So there's a former ATF agent who served for 23 years in the ATF, and his name is Dan Okelly. Now, Mr. Okelly was known as one of the top gun experts while he served at the ATF. He was also the lead firearms technology officer for a while, and he taught new recruits at FLETC, the Federal Law Enforcement Training Center. That's the police academy that the ATF attends. Since he's retired, he has a consulting firm as well as a firearms training company, and he's also an expert witness. And he's been doing some key expert testimony, not for the ATF, actually against the ATF. Yes, for the defense. Before we get a little deeper into this, the Gun Control Act of 1968, among other things, it was determined that the one part of every firearm that would be regulated was the frame or receiver, had to be stamped with the serial number for tracking. In fact, the definition, which I'll read you, is that part of a firearm which provides housing for the hammer, bolt, or breech block, and firing mechanism, and which is usually threaded at its forward position to receive the barrel. But according to former ATF agent Okelly, the AR-15 platform doesn't meet that definition, nor does up to 60% of the firearms in America. Now, I know some of this is going to be preaching to the choir, but the AR-15 has two receivers, the upper and the lower. And if you go by the Gun Control Act and the definition, which controls the regulatory parts and stuff on a firearm, neither the upper or lower in and of themselves meet that requirement, even if they're fleshed out. Why? Well, if we just refer back to the definition, it says the part that provides housing for the hammer. Well, that's in the lower receiver. The bolt, that's the upper receiver. The breech block, that's the upper receiver. The firing mechanism, that would be in the lower receiver, the trigger group, and which is usually threaded at its forward position to receive the barrel. Well, that's the upper. So according to the letter of the law of the 1968 Gun Control Act, the AR-15 lower, which we all know is the part that is treated as a firearm, doesn't even meet the definition of a firearm. And many of us have known this forever, but it's just starting to poke its head up again with all this craziness around the ATF. So former agent Okelly is making waves, especially at ATF. They're not very happy with him doing this, but according to him, when he takes that oath to tell the truth, the whole truth, and nothing but the truth, that's exactly what he does. And as a result, some people have gotten off some serious charges that they were facing related to illegal possession or sale of guns because they didn't meet the definition of a firearm. Now, yes, some of the people who got off might have actually been really bad people. I don't know. You can read the cases, you can search this stuff pretty easy. But he's not really getting off on getting the bad guys off. But what he is doing is telling judges when asked that these people are being booked or charged and threatened with prison for something that technically they didn't do. In one of the prominent cases under cross-examination by an ATF agent who was sent from headquarters to represent the government on a case, Okelly was asked, did you teach this fact that AR-15 individually, upper or lower receivers don't meet this definition? And he said, no, I didn't. That would never be accepted. And then the judge pressed a little more, and Okelly said that the higher-ups, the leadership at headquarters, told him that he could not teach anything that was not approved. and that wasn't approved. In fact, in a case last year in Ohio, it was back in December, U.S. District Court Judge James G. Carr, the Northern District of Ohio, called the ATF's long-standing interpretation of the regulation unreasonable and legally unacceptable. I'll give you one of the prominent cases where this actually means something today. This took place back in 2014, and the company was called Ares Armor, A-R-E-S Armor. And during that case, approximately 6,000 polymer non-gun parts were seized by because according to the ATF, they were receivers. Sounds like something like that is going on right now. At the time, the company's owner was never charged with a crime, something that's similar to what's going on right now. So he filed a civil lawsuit against the ATF seeking the return of his property. Okelly testified on behalf of the business owner, saying that of the receivers in question, they only had 2 of the 4 features required by the ATF's own definition of a receiver. This is the interesting part about the up to 60% of firearms not meeting the definition either. Okelly also noted that the definition failed to cover a long list of semi-automatic rifles and handguns, including the very popular Ruger 22 caliber pistol and Uzi style rifles. The regulation, Okelly wrote, pertained mainly to a part found in manually operated weapons such as revolvers and pump-action shotguns. Again, this is his words, not mine. He has testified in court, and he's won a lot of cases because of it. Okelly said in this case that the ATF's attempt to classify these items seized from Ares Armor as receivers, as well as similar rulings in other cases, displayed, quote, a lack of logic and consistency, which has created a climate in the firearms industry wherein it is nearly impossible for the reasonable man to be able to operate in good faith within the law. And that is not just in the receiver game either. Look what's going on with the pistol brace considerations that they're publishing. 2 days after former agent Okelly submitted his declaration, the ATF returned 5,786 lower receivers to Karas, the owner, and the case was dismissed. In another case regarding an AR lower, Kelly is on record saying it is simply a piece of cast metal that must be equipped with numerous parts in order to become a weapon. So over 50 years of the ATF's regulation of AR lowers, the stripped receivers, is a farce. And I wanted to bring this back to the forefront because right now is the open comment period related to the ATF publishing their classifications and characteristics that they may holistically, on a case-by-case basis, determine when judging if a pistol-braced equipped AR-15 is actually an AR pistol or a short-barreled rifle, thus regulated under the National Firearms Act, $200 tax stamp, fingerprints, photo, registration, can't leave the state, yada, yada, yada. There's a lot of stuff that the ATF does that is just out there. I mean, they basically get to do whatever they want, and they change policies and procedures and rulings ad nauseum. And it's really tough for the average law-abiding citizen in America. I know people don't like that term, but if a law-abiding citizen can't determine what the law means, then it's not really a clear law. And the ATF aren't elected to the legislative branch. They shouldn't be dictating law anyway. But I figured I'd put that out there just in case anybody out here watching this right now still hasn't commented in the open period. There are, I think, 12 days left in the open comment period. I'll have a link down below where you can go to that site. It's regulations.gov. But on the top right-hand corner, you click comment now, you type in your comment and submit it. Just remember, don't be vulgar because it's not going to count as a comment, and you're just probably going to draw attention to yourself. But it's time for the Second Amendment community to pull together, and let's push back against the ATF here, because once this goes into effect, when they publish what they're actually going to look at, the next step is what Joe Biden wants to do and put AR pistols under the NFA. Don't forget about the 25% off the holiday blends. Holiday 25 is your coupon code. blackoutcoffee.com/GNG is your website. Links will be down below as well. And if you're looking for Second Amendment news, no matter where it happens, good, bad, ugly, or indifferent, this is where you'll find it, here on Guns and Gadgets. Oftentimes, it's not good. Sometimes it is good. And this could be good as long as we put it to use in the right way. As always, thank you so much for your time. I appreciate it. I'm very humbled for your time and your support. Until we see each other again, please be safe, stay vigilant, and carry a weapon, and I will see you on the next one. Take care, everybody.